Hello again, and welcome to the Revolution Blueprint. I'm Rob Iobi, and this is our very first C in 3 segment, the Constitution in 3 minutes. The United States is facing a serious constitutional crisis, one rooted in judicial overreach. Specifically, district court judges are interfering with the Article 2 powers of the president. This interference is a clear violation of the Constitution's separation of powers. The Constitution establishes 3 distinct branches of government, each with its own enumerated power, but also with limited authority. Congress makes the law, that's Article 1. The President enforces the law, that's Article 2. And the courts interpret the law, that's Article 3. Each branch was designed to operate within its own lane. But in recent years, lower federal courts have overstepped, inserting themselves into matters of national security, immigration enforcement, and executive policy, all of which fall squarely under the authority of Article 2. This is more than a political issue. It's a legal and constitutional emergency that threatens the stability and security of the nation itself. The question is, how do we get here? It began with the Judiciary Act of 1789, which created the federal court system and granted original jurisdiction to district courts in federal matters. The same act also attempted to grant the Supreme Court the power to issue writs of mandamus, a court's order compelling government officials to perform specific duties. In the landmark case of Marbury v. Madison, the Supreme Court established the principle of judicial review, the authority to strike down unconstitutional laws. That decision created an important check on the legislative power, but it also expanded the court's power beyond what the Constitution explicitly allows. That said, the court's logic was grounded in constitutional reasoning. However, and this is critical, in the very same ruling, the court struck down Section 13 of the Judiciary Act, declaring that Article 3 does not grant the power to issue writs of mandamus. In simple terms, the court cannot command the actions of the president. Because the Constitution does not grant the judiciary the authority to control executive functions, the courts have no constitutional power to halt deportations, reinstate terminated federal employees, or compel the funding of executive programs. These are exclusive powers of the executive granted by Article 2. The judiciary's role is to interpret the law and determine whether a statute or action aligns with the Constitution, but it has no enumerated power to enforce its rulings. Basically, its authority ends at judgment. If the president is believed to have violated the Constitution or a federal law, the remedy is impeachment, and that power lies with Congress, not the courts. So what's the solution? Congress must act. Under its Article 1 authority, Congress can pass legislation to amend the Judiciary Act of 1789, granting original jurisdiction to the Supreme Court over all matters involving the executive branch. Such a reform would immediately end the judicial overreach by the lower courts and reaffirm the constitutional boundaries that protect the balance of the power in our republic. The Constitution is clear. Each branch must remain in its lane. It's time for Congress to do its job to defend the Constitution, restore balance, and end the abuse of judicial authority. Congress, do your job. The Republic is waiting. That's the Constitution in 3. I'm Rob Iobi. This is the Revolution Blueprint, and we'll see you soon.